6.5. Seventh affirmative defense, Mississippi Tort Claims Act. The Supreme Court held a state law that immunizes government conduct otherwise subject to suit under 1983 is preempted, even where the federal civil rights litigation is brought in state court. That is Felder v. Casey. Accordingly, the State Tort Claims Act immunities cannot bar a Section 1983 claims in either state or federal court. And just as a little a side note, no construction of any common law standard policy is as powerful as that. Through the 14th Amendment and the Civil Rights Act, Section 1983 pierces almost all immunity. The only thing you can't sue is the state itself, but you can sue a state actor. You can sue the governor. You can sue department heads. So you just can't claim a suit against the state for damages. For injunctive relief, you still need to have it to where a particular official is the one bound to act differently. You're just not getting any damages, but you can correct misbehavior. This is still in Felder. The court held that states may no more condition the federal right to recover from violations of civil rights than bar the right altogether, particularly where those conditions arise from immunity waivers that are entirely irrelevant insofar as the assertion of the federal right is concerned. Felder established that the Supremacy Clause preempts state court claims acts when they conflict with a Section 1983 remedial objective. So if it wasn't Section 1983, then the Tort Claims Act and immunity, sovereign immunity, can bar claims, is the inverse of reading that. So Section 1983 is one of the biggest sticks for redress that you can learn. 653. Mississippi Tort Claims Act provides no defense to federal constitutional violations under 1983 in any court of competent jurisdiction. 6.6. Eighth affirmative defense, estoppel and res judicata. The defendant's eighth affirmative defense asserts that the plaintiff's claims are barred in whole or in part by the doctrines of estoppel and res judicata. This defense is legally insufficient for several reasons. First, the county court's dismissal of a criminal case against a plaintiff due to due process violations supports her 1983 claims rather than bars them. The court specifically found constitutional violations in order to arrest warrant stricken, findings that establish rather than preclude plaintiff's civil rights claims. Second, collateral estoppel actually precludes defendants from relitigating the county court's constitutional violations. Under Allen v. McCurry, state court findings can have preclusive effect in 1983 action. The county court's unappealed ruling that defendants violated due process is binding and supports plaintiff claims. This case is distinguishable from Taylor v. Charter, a Fifth Circuit 1998 case, where courts cannot take judicial notice of another court's factual findings resolving different parties. Here, the same parties litigated these constitutional issues in the criminal proceeding, making collateral estoppel properly applicable. His role as a prosecutor establishes clear privity with the city as prosecuting entity, satisfying the identity of parties requirement for collateral estoppel. Oh, these cases were great. Like reading Taylor and Allen is where you learn that the term privity is necessary to trigger they looked at this. Yeah, they're right. And so you have to bring that up. You cannot just throw Marbury v. Madison out and think it's some magical sword. You can't say supremacy clause and and like it's just magic, and Dracula falls backwards and says, "Oh, you've won!" Blah blah blah. So this is this is it's real work, and when you're doing it right, it's very enjoyable. Unlike in Allen v. McCurry, where the plaintiff had lost on constitutional issues in state court, here defendants were the prosecuting parties who lost when the county court found constitutional violations. Having had full opportunity to litigate these issues as prosecutors and choosing not to appeal, defendants are now bound by that adverse determination. Fourth, defendants failed to identify what claims or issues were allegedly decided, creating unfair surprise under Woodfield. Allowing this vague and legally incorrect defense to proceed would substantially prejudice plaintiff in multiple ways. First, it would force plaintiff to expand significant resources conducting discovery and preparing arguments to counter a defense that has no legal or factual basis. Given the county court's findings actually support rather than bar plaintiff's claims. Second, it would create confusion in the litigation by suggesting that previously resolved constitutional issues remain open for reconsideration, potentially leading to inconsistent judicial determinations on the same issues between the same parties. Third, it would undermine judicial economy by requiring relitigation of constitutional violations that were already determined by the county court. Fourth, it would unfairly delay resolution of plaintiff's claims by introducing a meritless defense that contradicts established principles of collateral estoppel. Finally, it would potentially erode the finality of the county court's unappealed determination by constitutional violations, which the plaintiff has relied upon in bringing this action. This combination of increased costs, litigation confusion, efficiency loss, potential delay, and undermining of final judicial determinations constitutes substantial prejudice to the plaintiff that warrant striking this defense. This defense should be stricken as legally insufficient and factually baseless.